Off we go. All right, well, welcome to the Zoom session for, what are we now, week 3. And thank you to those that were able to join us last week. If you weren't able to participate in the live discussion, I have posted under the week 2 materials on Moodle, the recorded session. And as I mentioned last week, it is my intention to record these sessions and post them online just in case. I know a few of you have had difficulties with staying in the whole session due to internet dropouts, etc. But also with things going on in lives, if you can't participate in that particular night, it gives you the chance to have a look at it in your own time. I guess the key thing I wanted to mention first of all, and I hope you are all aware that the first assessment item is due this week, and it's the semester plan. The instructions for which that assessment item are given in the week 3 section of Moodle, and there's also some information in the course profile as well. But really, I just wanted to reassure you that this is not, while we call it an assessment item, we're not strictly assessing you on much other than your submission, firstly, of this piece of work, but really that you've put some effort in at this stage in the course to managing your time, or to put in place a plan for how you are going to achieve your study objectives this semester. And how you're going to complete all of the assessment tasks on time. Everyone's very busy. Most of you, I'm sure, are working, but you're certainly also studying other courses. So how are you going to bring all of that together with the work, extracurricular, family activities that you have? There is no strict criteria sheet in terms of my marking of this, and really my intention is, provided that you submit this piece of assessment, and provided that you've put in a genuine attempt to set out a semester plan, and it's a pragmatic assessment plan. I mean, it's like going on a diet. You can say that you're going to lose 5 kilos in the first week, but are you really going to be able to stick with that long term? So do put into place something that you can achievably meet throughout the semester. So provided you do that, there shouldn't be any shocks when it comes to the marks. Okay. Josh, she says it a strict 3 pages. Well, 3-page, probably should be fairly generous. I think if you're going over the 3 pages, well, you must be a very busy person, but also maybe you're just putting in a bit too much detail. I think that's probably the maximum. And as the instructions say, that is just a suggestion as well. You might prefer to almost do it as a calendar or a running timesheet. I'll leave the format to you. Again, I'm not strict on that. But that's if you are just going to do it as a a 4-page dot point type plan, then 3 pages should pull you up. So a few of you have asked about cover sheets as well. If you can submit it with a cover sheet, it's a good idea, because technically it is a piece of assessment, the course, and they should all have cover sheets. But certainly I'd encourage you to all put your names and your student numbers on each page as well. So do it as a header or a footer. I'll be marking most of these online, but occasionally my eyes start to get the better of me, and I do like to print them out and mark them from there. So it's just to ensure that I've got all of the pages together. Again, the criteria sheet, I've addressed that there is really no criteria sheet for this piece of course, other than the instructions that are given to you under week 3, and then also in the course profile. Okay, so I hope that clarifies this for everybody. Sorry.
And I've done it on a spreadsheet. Mm-hmm. Do we have to do it on a Word document, or is a spreadsheet okay?
Look, I don't really have a. If you can do it as a spreadsheet, I guess, if that works well for you. Yep, and you think it's clear and then readable for the marker, I'm sure that's fine.
Yeah. Okay.
Okay.
Thanks.
Anyone else have any other formats that they were trying to play around with or wanted to submit as? No. So, I mean, point two, if you look at those instructions, it says the plan can be any format the student prefers. So, for instance, you could do it as a table or a calendar or a to-do list. So, spreadsheet's certainly fine.
Yeah.
Thank you. And the next piece of assessment, which I've briefly touched on already this evening, is the online quiz. And that is next week. So there's 10 questions, I think, from memory for that one. And they're each worth, half a mark each. So they won't be, overly difficult. It's not my intention at this stage of the course to try and catch you out, and we're certainly not distinguishing at this point in time between the higher distinctions, etc. It's again really almost a formative piece of assessment to get you keeping you up to date with the materials more or less, and if there are any problems to identify those early. Margie, yes, there is a 30-minute time limit. I thought that was enough for a 10 question multi-choice exam. So I guess to take out of that is you can choose to do this exam, I think, any time within that. I think the dates escape me, but you've got about a week or so to actually complete that quiz. But you do only have 30 minutes. So try and pick a time where there's going to be minimal distraction, or you can lock yourself away and lock the dogs and lock the kids away too, so that you can complete it without distraction. So you don't want to get locked out of within that time. Okay. So that's the assessment at this stage, and hopefully you're all ticking away nicely with the course materials. Any quick questions before we make a start on the material for this week? No? You've all been able to get a copy of the textbook?
Yep.
Textbooks. If you haven't, the book, I'll try and show you from here. Looks, you probably can't see that good an image, but that's what it looks like. And then with the accompanying case material, which is the yellow one, okay? A few of you asked about the ebooks. You can contact the publisher, if you like, which is Oxford University Press, and see if you can get them as ebooks if you would prefer that format. A few of you, again, have asked about previous texts. As I said last week, it's my responsibility to tell you that these are the prescribed texts this semester. So if you choose to deviate from that, I mean, there are many contract law textbooks out there, but I will be using these ones in terms of setting the assessment, etc. I would strongly encourage you, again, to get the case book, which does come in a package, purely just, as I said last week, the level of information it gives you about cases. It goes into more the various judgments that are made. I think that's necessary for a law course. Okay? We will, as we get closer towards, I guess, the more challenging pieces of assessment in this course, and certainly to the take-home exam, we will be spending a bit of time talking about how you should write answers to questions and the level of detail that you should go into. And one of the things that really we do expect of law students vis-a-vis business law students is case commentary. Business students that I've taught law to in the past, it's enough for them to cite the name of an authority. Such as, when we get into the law about offers acceptance, to say Carla Lung Cubble at Smokeball Company, and we give the business students a big tick because they've actually recognised the name of that significant case. But for law students, we actually expect some discussion, where appropriate, about that particular case, the key facts, points of law, if there are certain, key passages that judges have made in that, for instance. then we would expect you to identify those. Again, where appropriate in your discussion. And sometimes when you get into your higher level law courses, we would expect students to talk about the dissenting judgments or how the judges differed in their approaches to particular cases. So that's why the casebook is necessary. Okay. Any questions on that? No? I've got a bit of chat going on here, so I'll try and keep up with the chat as well as the discussion, but please interject me if there's anything you'd like me to talk to further. All right, well, the material for this week was concerning the topic of capacity. Can anyone explain to me what capacity means in this contract law context? What does capacity mean? Say someone has capacity to contract or someone lacks capacity to contract. What are we referring to?
Is it the capacity? Sorry.
Yes.
The ability to make a decision at the time of the transactions taking place.
Okay, so the ability to make a decision.
A sound decision.
Sound decision. Yep, sure. Yep. And Josh says their state of mind. That both of those comments are true. Why is that important?
Because the person has to be over 18 and mentally capable of making binding contract.
True. Again, so they are particular circumstances where a party may lack capacity and may not have the requisite ability to understand what it is that they're doing. But I guess my question is, why is it necessary for a party to have capacity?
That they're acting in their best interests, perhaps?
In their best interest, yeah. Yes, that could be right. So that they, I guess, building on that they understand what it is that they're doing, what it is.
Not acting in. Sorry, not that. Whatever they're doing is not going to be to their detriment.
Okay, good, thank you. And Mark, you say it's to protect them. To protect the, I guess the party here that may lack capacity is I guess what you're saying there, Margie. Yep, and we've seen from the readings this week that some of the key parties that are often said to lack capacity are parties such as minors, whom in Queensland at least a minor is defined as a person under the age of 18. Okay. We also say that parties can lack capacity if they are suffering from something such as a mental disability, okay, or mental impairment. And built into that theory about mental impairment are persons who may be affected by intoxicating substances, be it alcohol or other drugs, etc. And then the law also recognises that people like bankrupts and criminals can also lack capacity for different reasons, as I hope you've gleaned from the theory, such as bankrupts. Under the bankruptcy legislation, they're considered to have no contractual capacity because of the fact that their affairs are taken over by the official trustee in bankruptcy. So they're seen to lack any power to contract outside of the trustee in bankruptcy. And similarly with criminals, if they are convicted and sentenced to imprisonment, the public trustee takes over their affairs and their financial dealings. So therefore they can't contract in their own right. But if we come back to this notion of capacity, what we're really talking about and why we're looking at it at this stage in the course is you'll remember from last week when we looked at all these different theories about contracts and how contracts are formed and the rationale behind our contract law theory. And you'll remember that one of the approaches we looked at, which was the classical theory, basically says that people should be free to contract on whatever terms they see fit, or paraphrasing Okay, so that we as individuals, we have the liberty, the freedom to enter into contracts, and who is the law to interfere in that? Okay. So if I want to sell you my house for $1 and you want to buy my house for $1, at least at contract law, we should have the right to do that. Okay. But when we look at that particular transaction, let's say that I'm selling you my house for $1 and you want to buy my house for $1, in order to say that that is a valid agreement, and it's the key word there is an agreement, what we need to show is that the parties have come to that agreement with a meeting of the minds. Or, in other words, that the parties both clearly understood that they were entering into a contract and what that contract contained, or was basically the effect, if you like, of that contract. What would then happen to them? Okay. So that if they didn't do as they promised to do under that particular contract, there would be legal consequences. And unless we can show that both parties actually clearly understood or had the requisite ability to understand, firstly, that what they were doing or what they were agreeing to was a contract, and then secondly, the consequences of that contract, we can't say there's been any real agreement. Okay, so when we're looking last week at the issues of mistake, okay, and we talked about the different types of mistake. Okay. I said, for instance, if I've got two BMWs, one's black, one's white, and you've seen me driving around these BMWs, and you approach me and you say, I want to buy your BMW. And you've actually seen me predominantly driving around in a white one, so that's the one that you're talking about. But I'm actually interested in selling the black one because it's older model and I want an upgrade. So I agreed to sell you my BMW, thinking that it's the black one, and you think you're buying the white one. In that case, obviously there's a mistake that's been made there, and you can look at the theory from last week to see what type of mistake. But there is no meeting of the minds. We haven't reached an agreement, okay? Because quite clearly we're coming at it from different angles or different mistakes being made. So that's what capacity is looking at as well, the fact that the parties, for whatever reason, may be impaired in circumstances because of their minor age, because of their mental state, or because they're intoxicated, and therefore they can't understand or have the requisite capacity to comprehend the contract, firstly, and then secondly, the consequences of that. Okay, so I hope that clarifies any uncertainty there about why capacity is so important to show that you do have it. Okay? And again, when we're going through this theory, this course is, if I can say, written or presented in a way that's different to other approaches I've taken to contract law in the past, or other subjects I've taught. Because normally in contract law, what we teach is the fundamental elements of a contract, first of all, and we start looking at that theory next week, I think, from memory. But that you've got an offer, you've got acceptance, you've got intention and consideration. And those are what we call, under the common law, the fundamental elements you need to prove in order to show that you've got a contract in existence. And then from there you say, well, I've got a contract in existence. Are there any circumstances which might render that contract void or voidable? Okay, so you start looking at things like, are there mistakes? Are there, is there misrepresentation? Is there a lack of capacity on one of the parts, etc.? Okay, so we're doing it in reverse in this course, and it kind of makes sense, because what's the point in actually proving if there is a contract in existence if the parties lack capacity? If there's no capacity, if there's no ability to reach an agreement, then the contract doesn't exist. Okay, or can't survive is probably the best way of saying it. So that's the essence of why capacity is important to consider, okay, and to understand. And as I also mentioned last week, I think one of the students raised the tutorial question in the Zoom session last week. When we're talking about things like a party lacking capacity because of, intoxication, let's say, they're alleging that they were drunk at the time, and perhaps they were at a Christmas party, which they're all coming up shortly, they were basically not in a situation to be able to comprehend what it was that they were doing. When we're talking about intoxication there, we're not just talking about having a few drinks and perhaps being a bit tipsy, as we like to say. We're talking about intoxication to the point that your faculties are impaired, that you really cannot comprehend the consequence of what you're doing, and the importance of what it is that you're agreeing to. As we also look at the theory tonight, the other party needs to have been aware of that and needs to have taken advantage of that, or certainly not taken any precautions to safeguard you. Okay. So questions from any of those comments? No? Okay.
Just
yes.
one question.
Sure.
Just on the intoxication point you just raised, is it similar to proving intoxication in a criminal matter, say for drink drive? Like, for example, to prove impairment or intoxication, it usually had to be a major reading and had to be some visible signs of indicia. Is that the case with contract law as well? Does it get that? And how do you prove that you were
It can, Nick. I guess the only problem with looking at intoxication in terms of contract law is that, again, it depends on it depends on the nature of the contract too. I think in the study guide it had something there about, a person whom is intoxicated can jump into a taxi at the end of a long night and comprehend that once I get to my destination, I need to pay the taxi driver for this contract that I've actually engaged in by giving me transport. So they can comprehend that. But if you were to take the same person in the same intoxicated state and have them sit down and sign a bank guarantee or a loan document, etc., that's different context. So, things like looking at their blood alcohol level or other indicia could be relevant, but you do need to look at it in the context of the particular contract as well. And just because somebody is, blowing over 0.05 and technically at law would be considered intoxicated, doesn't mean that they weren't able to comprehend their actions or the nature of the agreement they were entering into. Right. Anyone else? No? All right. Well, let's have a quick look at the theory then for this week. Okay. So really, I'm not going to go through it in any great detail because the lecture has done that, but to point out the key circumstances again where parties may be said to lack capacity is where they are a minor, okay, and a minor, as I think the definition you're given on page 5 of those lecture notes says, in Queensland, a minor is a person under the age of 18. Okay, so we've adopted that uniform age of minority across a lot of our key legal provisions. So when we're talking about minors and capacity, I guess we start out by looking at the general rule which says that a minor can enter into a contract. Okay, they're certainly not prevented from entering into contracts, but those contracts will be voidable, will generally be voidable at the election of a minor. Okay, so we take that as our starting point. And by the word voidable, what I mean there is that the minor will have an election, a choice, to be bound to that particular contract or not. Okay, so we take that as the starting point. There's nothing to stop minors from entering into contracts. Some types of contracts, we won't deal with that now, but under various statutes, etc., they can't legally. But generally the position is they can enter into contracts, but they will be voidable. Okay? So if a person under the age of 18 enters into a contract with an adult, okay, as a general premise, the minor will have the opportunity or the election to get out of that particular contract, whereas the adult won't. Okay? The adult will be bound. Now, from your reading, you'll see that there are some circumstances, though, where the law deviates from that general position and says, for instance, the key one is where a minor enters into a contract for necessaries, or necessities, as it's often referred to as well, the minor will be bound to that. Or where the minor enters into a contract for beneficial services. Okay. Can someone explain to me what we mean by contract for necessities or necessaries, depending on which theory you're reading?
Employment, accommodation, and clothing.
Employment, does that generally come within necessities, or?
I guess it's the contract itself, is it? Not so much the. Sorry, I'm not sure if I'm making sense.
No, you're right. You're right. Generally, we think about employment as being in the contract for beneficial services, so employment contracts or contracts which relate to the educational enhancement of the particular individual. Generally, when we're talking about necessaries, or does someone else want to volunteer further definition of that?
It's things that are appropriate for the person's circumstances in their life at this stage. So not necessarily just the necessaries that we think of, like shelter and food and clothing, but it can extend from that.
Sure. Well, certainly food and shelter, as you rightly said, do fall within necessities or necessaries. But they are things beyond that as well. And as you did point out, we look at the particular individual involved, okay, because what might be appropriate for, I think the lecture notes refer to a prince, would be radically different from, let's say, the pauper. Okay.
Yeah. Like education. Yep.
Yes. So generally, we look at the particular individual involved, and I say, well, what is necessary for that individual's station in life? Okay, what do they ordinarily need to be able to firstly survive, but to be able to continue their ordinary life on a daily basis? Okay. So that's necessaries. And the other key circumstance I said where a minor will be bound to contracts is where we've got a contract for beneficial services. And these are typically contracts that the minor enters into for their employment or for their education, advancement of education. Provided, big caveat there is, provided that those types of contracts are actually beneficial to the particular minor as well. So they're not, expecting them to work, detrimental hours or under unfair circumstances, etc. Okay. So the theory that you've got in your lecture notes is very comprehensive. You've got some good case law there that illustrates, the particular individuals involved, how one person's circumstances might produce an outcome different from the other, such as those Cambridge scholars and their various tailoring requirements there. Some other key terminology that you need to be aware of are those 2 R's, the ratification and repudiation. Okay. So if one is to ratify something, what we mean is that perhaps something that was unauthorised or something that was incorrect has happened, but subsequently we've consented to it or acquiesced to it. Such as I often use for my business law students, the example that they all have normally 3-hour exams that they need to sit, and those exams are open book. And often I'll say to them when we're talking about ratification that, let's say we're in the exam and you're under the care of the invigilators, and I subsequently walk into the exam about half an hour late, and I see that they are all sitting there with their notebooks and their textbooks, etc. And I say, what are you all doing? You know, you shouldn't be having your books in here. I know normally that the exams are open book, but I specifically told you that this was closed. Okay? So they've already done the wrong thing. They've already been using their books for a certain period of time. And then I say, well, damage is done now. Let's just stick with it anyway. Okay, so that's effectively ratification. Okay. Repudiation is a term that we'll look at later on in a different context in contract law. But with repudiation, there is a clear rejection, if you like, of the contract, or a clear statement of, no, I will not be bound, no, I do not intend to be bound by this particular contract. I'm not going to fulfil my obligations. So a renunciation, if you like, of the contract. So they're the 2 R's that you need to be aware of as well. The flow chart that you've been given on page 6 of those lecture notes is very helpful. There could have been, in terms of the section about, you know, is either party drunk or under a mental disability, a few more arrows there. But I think purely just for the way that it reads on one page, they were omitted. But for instance, it says, is either party drunk or under a mental disability, and you're really just prompted to follow those yes and no's underneath it. But the very helpful explanation anyway, and also how, in terms of with the minors and contracting, the incorporation of some of those sale of goods provisions as well. Did anyone have any questions about that or the theory generally before we start looking at these tutorial questions? No? Okay. All right. Well, let's have a look at them. So, again, if you didn't join us last week, I intend on using these sessions, you know, as a general discussion, but also as an opportunity to go through the review questions in the lecture notes. There is also just to point out, at the end of each of your chapters, some questions for reflection. And for this week, they're on page 166 of the textbook. I mean, I'm happy to go through those as well, but I just in the interest of time, will prioritise those in the lecture notes. But do, make sure you're aware of those questions for reflection at the end of your chapter readings, and do give some time to thinking about responses to those as well. Okay. So the first question is on page 8 of those lecture notes. It's question 1 under the section review questions. We have Eric, who is 16, and he books an airline fare online and pays for it with a debit card transfer. The airline's terms and conditions state that Eric will be required to pay an adult fare, as all travellers aged 15 and above, are treated as adults for the purpose of the contract. Is the contract, and you've got a number of options there, A to D. Could someone volunteer a response to that, or which is their answer?
I had D.
D? And sorry, it's Michael. Michael, why did you have D?
Well, I just said the starting point was that Eric's a minor. Mm-hmm. And so going from that, the starting point is that the contract's voidable unless it's for a necessity or a beneficial contract. And I didn't think that fitted either of those. So it was voidable because he's a minor.
Okay, great. Yes. Anyone else have D or a different response? Margie, you had A. Is there a reason that you picked A, or why did you think that was the...
The only reason I picked A was because really with the experience from booking airline tickets in the past, and I've never known that I've ever been able to get out of an airline ticket booked for a child. That was all. That was really the only reason I said that.
Yes. Yep. No, that's probably practically true. And again, as I mentioned last week, we somewhat, when we're doing all of this theory, we somewhat have to put our blinkers on and forget about the other topics that we'll be learning about down the track, or how other areas of law may impact upon our answer. And we have to try and look at it in context of what we're learning in a particular week, which is very hard. Yeah, I take your point that, try arguing with the airline, I'm a child and I want to get out of it. You probably won't be met with much success. But look, I had D for this answer, which again, if you haven't got the notes in front of you, said it's voidable by Eric because he is a minor. Initially, I did have A as well, Margie, and the reason I did put A was just in thinking about, the way that you book airline tickets as well. You have to tick the box that says, I confirm I accept all of the terms and conditions. So in essence, it could be said that you are, I guess, affirming that you do intend to be bound. But if we look at it purely in the context of the theory that we're covering this week in capacity of minors, I think D is the best answer there, which it's voidable by Eric because he's a minor. B is not the right answer. It's not void because minors can contract, and void means that the contract is cancelled out or almost like it never existed. C is not the right answer because the airline does not have the election to get out of the contract. It's not voidable at their benefit, but it's voidable for the benefit of the minor. So I went with D in the end there. Okay. Question 2, why are contracts made by minors voidable rather than void? Okay, so voidable meaning that the minor has the election. Void means there is no election, the contract's cancelled or doesn't exist effectively. So I'd like to volunteer an answer here for me.
Maybe A.
Mm-hmm.
Because as you stated previously, minors need to enter some form of contract while they're a minor, as minuscule as that contract may be. You just can't brush them for 16 years. Yes,
agreed. Okay. Certainly, B to a certain extent is partially correct. Minors do require protection from unscrupulous parties. However, the second part of B I don't think is right. So while those parties require no protection from minors, it is possible that the other contracting party does need protection from a minor. For instance, when we're talking about minors whom are they're child celebrities, let's say, or, they're children at a very young age whom are thrown into, don't want to use names too much, but look at someone like Bindi Irwin, who from the age of a toddler was extremely famous, and or Macaulay Culkin. Does anyone remember Macaulay Culkin from Home Alone? That child celebrity. They were making megabucks at a very young age, and perhaps the other contracting parties did need protection from them. But A is the better answer because, as the case, you've certainly got a passage in your lecture notes from the case of Zajdi Abbott and Hallett Parsons. Where I think it was Lords Mansfield articulated that the law surrounding the capacity of minors is really there to give the minors the benefit to participate in commerce, should they wish to, but then also to afford them some protection in circumstances where they may be dealing with unscrupulous parties. So summarising all of that, I agree with you, Nick. I think A is the better answer there, to give them the benefit to participate. Good-o. All right, so moving on there. Page 13, you've got 2.7 review questions. Question 3, which of the following would you regard as a necessity for a 16-year-old minor who has a guardian but no parents? So you're given some options there of A to G. What do we think for this one? What would we consider as a necessity for a 16-year-old minor who's orphaned? Anyone have a view?
I said A.
And why did you say A, Hayley?
Because so with transportation, obviously with no parents and with a guardian, as it says, transportation would be pretty needed. So their go card would be a huge necessity, especially if he lives in Brisbane or somewhere like that.
Yep, perfect. Certainly. Anyone else have a different question? Margie, you say A, or a question for D as well. Renee, you say A, B, and D if he's a student. I don't actually think that there is necessarily a right answer for this, because again, when we're talking about what is a necessity, we need to consider the station in life of the particular minor. And again, Hayley, I think that the transportation go-kart, for instance, could very well be considered a necessity, and probably is. B, a smartphone. Look, if you ask most teenagers today, they'd probably say that they couldn't live without their smartphone. The reality is that they probably could. It's a very helpful convenience, but is a smartphone really necessary to allow them to exist, in their ordinary life? I don't know. Maybe I'm coming at it from an old school perspective, pre-mobile phone perspective. But look, it's arguable. A trendy wardrobe, definitely not. No, they can go shopping at Big W and that will do them nicely. A D, a laptop computer. Look, I think a laptop computer is probably a fair necessity, particularly given that you make the presumption that a 16-year-old minor is at school still. They need computers to be able to complete their assessment, etc., do their schoolwork. Maybe they could go to a computer lab or an internet cafe, but practically a lot of assessment is even now done online for schools as well. So it's arguable. A gym membership, E, no, they can go for a run around the block or go and play netball or something like that instead. A 6-month pass to Dreamworld would be nice, but no, I don't think that's a necessity. And a surfboard, again, would be nice, but no, they can just body surf, I think. Mm-hmm. So you can see there's a number of possibilities there. I guess in answering this question, if you were to have something like this on the take-home exam, you would need to go through the theory about, when minors will be bound to particular contracts, when they'll be say to lack capacity. What do we mean by a contract for necessity or for beneficial services? And use that as your starting point. Go through then and indicate what may be considered a necessity and why you think that. All right. So possibility of multiple responses there. Question 4, we've got Andrew here, who is aged in his early 30s. He walks into an electrical store to purchase a new SLR camera. The full price of the camera is $850, but the sales staff offer him a $150 discount. 10 minutes later, Angela, who is aged 17, I beg your pardon, walks into the same store and looks at the same camera. The sales staff do not offer her a discount. Which of the following is true? We've got options A to D there. Can someone volunteer an answer? Margie, you said A. Anyone else?
Yeah, I said A.
A?
Mm.
Why did we say that, Michael and Margie? Yeah.
Well, again, the starting point being that she's a minor, looking at that, it's the contract's voidable, but the question is the camera necessary?
Mm-hmm.
And just looking at the facts that we're given would suggest that it probably isn't.
Mm-hmm.
Unless she's a professional photographer, but I don't know, at 17, she probably isn't.
No.
So the Sale of Goods Act is irrelevant because that relates to
That's right.
necessity.
That's right. No, I agree. A was the answer that I came up with as well, and for the same reason that we have no information that Angela is, studying photography or, has a educational desire to be a photographer, etc. So there's no genuine need or real need there for particularly an SLR, a very expensive SLR camera. The sale of goods legislation, B and C are not the options there, because even though that the sale of goods legislation says that a reasonable price needs to be paid, etc., the starting point for the sale of goods is that you see a contract for necessaries, and it's not considered a necessity here for this particular minor. So A is the correct answer. Thank you. Question 5, which of the following would not be a beneficial contract of service? So what's a beneficial contract of service again?
Something was employment was one of them.
Employment?
Yeah.
Employment, apprenticeship, but to the benefit of the minor?
Yes. So employment or educational contracts which are beneficial. Okay, so as I mentioned earlier, you might have a fact situation where where the minor has entered into an employment contract, but the working conditions or the hours that the minor is required to work are excessive. Okay, so therefore we could say that particular contract is actually not beneficial to the minor. It might employ them, it might give them income, but it's detrimental in other aspects to that particular minor. So looking at options A to E there, what responses did we have for which of the following would not be a beneficial contract service?
Perhaps D, depending on the specifics of the contract with the modelling agency. I didn't go for B because it's basically stipulating that they're getting paid. It's 1 day a week. They're obtaining experience in the industry. It sounds like a sort of give and take, fair, equitable sort of contract, whereas D, maybe it's just me, but a modelling contract, really, it just sounds a bit grubby on the face of it, straight up.
Yeah, it depends, isn't it? I mean, it could be a modelling contract to take images for billboards or something like that, or promoting a local shopping centre or something that is I guess we'd say child friendly or appropriate. We don't have much in the way of details as to that particular contract. A few of you are saying C. C was actually the answer that I came up with, and for the reason that, I didn't say A because quite clearly we've got a contract here between the minor and the TAFE college to basically give the minor an apprenticeship or training to be an apprentice chef. So therefore that's an enhancement in their education, but also to hopefully leading to employment. B, I didn't say, as they are working for pay and it's 1 afternoon a week, so you couldn't say that was particularly arduous, and they're getting paid to obtain industry experience, so ultimately to hopefully work in that industry. So therefore I think that one's not the right answer. I said C because it's a contract with a placement agency to provide the minor with the opportunity to spend a year teaching English in a developing country. While you might say that that could lead to employment or improve their education, etc., I impliedly read into that that was a volunteer position, given that they're a placement agency rather than, it didn't read to me like it was a job as such, but more an overseas volunteer position. So while it might read well and enhance the minor in other ways, I didn't think it fell within the definition of beneficial contract of services. D is questionable. Yeah, life experience, yes, that would come into that, but probably, sorry, back at C, I didn't think that was right. Modelling contract, we need more information, but it could be very beneficial to the minor. It could bring them in some nice income, and depending on the sorts of modelling work they're doing could be a very good thing. And E, quite clearly, that's beneficial to the minor. Okay, it's tutoring services to improve their educational prospects. Okay. Question 6. So a minor signs up for a pay television service. The length of the contract is 24 months, and the minor reaches adulthood after 7 months. The minor continues to watch pay television for 2 weeks after their 18th birthday, but then they decide the contract is too expensive and seek to repudiate it. Which of the following is true? And you've got options A to D there. Someone volunteer answers for me?
B.
B? Yeah. So the contract is valid and enforceable at all times. It would be valid only if well, again, it depends upon, your perceptions here, but it would be valid only if the contract was deemed to be a necessity or was deemed to be of beneficial services. Again, some teenagers might argue that pay TV is a necessity, but probably not in this circumstance. So we've got C coming in from a few people. I actually went with C as well. So the contract was voidable until the minor turned 18, but has since been ratified. Mm-hmm. In terms of the ratification, what is the ratification, do you think there?
He confirmed it by watching TV for another 2 weeks. Mm-hmm. Although I just wonder, is that period of time long enough to ratify?
Yeah, thanks, Michael. I was going to pose that question to you all now. I mean, generally, in terms of repudiation, or once the minor has reached an age of majority, that is over 18, we say that repudiation has to occur within a reasonable period of time. Now, he has paid TV. It takes 2 weeks then to actually try and cancel that contract. 2 weeks goes pretty quickly, as we all know. But in the context of a contract which is 24 months, and he's only had that contract for, let's say, 7 months and 2 weeks, thereabout, is that a reasonable period of time? I did say C, but I did quiver with D as well, as to whether it was appropriate, just knowing how quickly 2 weeks does pass. So... did anyone have any other views? Or
I think if the pay TV company could somehow prove what he was watching or how he was watching it, they'd have a good case. It's all in the evidence they can bring forward. I mean, maybe he sat on his bum in front of the TV and watched a Stargate marathon for a whole weekend in that 2 weeks. I mean, for me, he's taking full advantage of the service. But if he just had it, if they couldn't prove that, then I don't know, you got nothing really. 2 weeks could be deemed acceptable, I would think, or not acceptable if they couldn't prove that he was actually using the service.
So you think he may have downloaded a lot of those movies on demand or whatever, racked up a big account of additional features or movies, etc. In that sense,
well, if he's
clearly is showing an intent to. Yeah.
Yeah, if he's downloaded stuff, that's gold. That's evidence they can produce to say that, yep, he's still using the service.
Yes.
And the contract stands.
Yes. Renee, you asked the question, or you said that you don't believe he ratified it. With ratification, you can actually ratify by, I guess, your acquiescence, or sometimes your failure to do nothing, if that makes sense. So by continuing to watch the pay TV, I beg your pardon, by continuing to use the service and not positively doing something to indicate you don't want it anymore, that is actually taken to be ratification. And, you know, later on in your theory, you'll talk about, well, there are examples of, you know, when you subscribe to some of those, what do they call it, the wine, you know how wine companies, you can sometimes subscribe to have, you know, a dozen wines sent to you to test out. And you know, let's say you have one bottle of wine and you're not really, you got 30 days to pay for it, sorry, I should say. And you have one bottle of wine and you think, oh, actually, that's a bit ordinary, but I'll try another bottle of wine, and well, that's a bit ordinary too, but I'll keep trying and see if I get to a good one. And then you write to the wine company and say, well, I don't actually want those wines anymore because they're all very ordinary. And say, well, hang on a minute, you've drank the whole box. So by your conduct, you've actually shown that you've ratified, okay, you've positively accepted. So continuing to watch pay TV and not do anything about it would be ratification in that circumstance. And thanks, Mike. You say the terms of these contracts usually require you to terminate the contract if you no longer require it to be binding. Okay, so C and or D are possible there, but it would probably require a little bit more explanation as to whether he downloaded movies or what the extent of his usage was. Maybe he didn't even watch pay TV during that 2-week period. Might have been on a holiday or something like that, celebrating his 18th. So in that circumstance, you know, D could well be the correct answer. Okay. So these questions are designed, I should say, for discussion purposes as well, so getting us to think about the different possibilities and understanding of the theory. On an exam, they're generally more definitive. Okay.
Sorry, can I just ask a question,
Yes.
Anna, with regard to that comment you were just making about exam? You really can only go on the facts that you've been given, though, can't you? Like, yes, you can't. You can't really read anything into it more than what you've got in front of you.
When you've got a problem-based question, you can sometimes, depending on the time permitted, you know, pose some competing scenarios. But obviously in a multi-choice question, you just have to go sometimes with the preferred answer. Okay.
Yeah.
Sometimes there will be 2 correct answers, more or less, but you have to work out which one is the better answer in the circumstances on the facts that you have. Yeah.
Okay. So there's still multiple choice in this subject, is there? Because I thought,
Yes, there's certainly multiple choice in the online quizzes. The take-home exam, I'm still working out the exact format for that. It'll probably be more problem-based, but the online quizzes are actually multi-choice. Okay. All right, so then you've got the question at the end, which is the tutorial question. I won't read through all of the facts. I hope that you've done that in your own time, but essentially you've got Glenys, who's a seamstress, and she sews dresses, and she's got 2 customers that come to see her. One is a young girl who is aged about 17 and wishes to buy a formal dress. She picks one that she likes, but it's perhaps a little racier than a girl of 17 would normally wear. Some alterations are made, but all the same, the dress is still a little bit provocative, I think the text refers to. Then you've got the second customer, a lady called Jenny, who is in about her mid-20s, and she wants to buy a ballroom dancing gown. Okay? And particular dress is ordered for her from the United States. I should say the first customer paid for the dress and the alterations on the spot, and the second one only pays for a deposit on the fairly expensive dress. The first customer comes back in to pick up the dress, and she's accompanied by her mother, and the mother says, nope, not getting that. The second customer says that she, at the time of agreeing to purchase her ballroom dress, was labouring under a depressive condition which she needed to take medication for, but she was unmedicated at the time. She doesn't want to now proceed. So what is the seamstress's rights in relation to those contracts? Are they enforceable? Why or why not? So in terms of the first situation where we've got the young girl, just trying to pronounce her name, Nyama, we'll call her Nyama. Okay, she's 17. What do we think the situation is with respect to her? Will Glenys have any right to enforce that contract, or what would the law state in that situation?
Margie here, Anna.
Yes, Margie.
I actually answered this on the discussion forum. Mm-hmm. I believe that she's a minor, so the contract is voidable unless it can be proved that it's for necessaries or of beneficial service. Mm-hmm. And I guess it's a subjective view as to whether it's a necessary or not, and my view is it's not. Mm-hmm. And so my opinion is that the contract is voidable, and therefore she should be able to get her money back, because there's no consideration in that she hasn't received the dress, the goods. Mm-hmm. And I guess the difficulty with that is you think to yourself, wow, fancy having the dress altered and everything, and then the contract's not being binding. But I guess from a, retailer's point of view, you'd have to be careful, because you know that a contract with a minor can put you at risk in that situation. Mm-hmm. That was my take on it anyway.
Sure.
Don't some stores, they won't enter into contract minors, the parents have to be there, or someone over 18?
Yes, and again, there's a circumstance where we might put our blinkers on, but the consumer law deals with this a little bit differently, and a store is within their discretion not to, to contract with a minor, and actually some statutes prohibit contracting with minors, such as the sale of alcohol, cigarettes, etc. So it does deal with it a little bit differently. I guess we talked last week about this question a little bit, and I said it is subjective when we're looking at what might be a necessity. Perhaps if you are a young 17-year-old girl ready to graduate, your school formal is a necessity, and having a dress for that is a necessity. And I mentioned last week that perhaps buying a nice off-the-shelf, should we say, budget dress could be considered a necessity, but buying a Dolce & Gabbana $2,000 dress certainly would not be considered, unless you were a princess or child celebrity, etc. However, I guess here, Margie, I pose the question to you: do you think it makes any difference in this circumstance, and this is purely for discussion purposes, that the dress was provocative, that it was, somewhat inappropriate for a girl of that age? Do you think that makes any difference?
I don't think so. It didn't enter into my mind at all. And I guess that was because I was trying to work through the processes, in that I did actually put my blinkers on for this one.
Good. That's great. And do you think, just in terms of, and again, I'm throwing it out there for discussion purposes, that the purchase of the dress and the alterations are separate transactions, or did you consider them as one transaction?
I considered it as one transaction.
Okay, so to buy the dress as altered.
Mm.
Yep.
Yeah, correct.
Okay, great. All right, no, that's good. Well, I mean, certainly. Sorry, yes.
Just a quick one. Margie mentioned the consideration part, so that's what I said as well. Given that there appeared to be no consideration given, although she paid, obviously the girl paid in full, but there was no consideration on the dressmaker's part. Is that correct?
Well, I would actually say that there was consideration on the part of the dressmaker, as the dress was altered. So something positive was done on the part of the dressmaker.
Right.
He didn't hand the dress over then and there because the dress wasn't fit to be handed over then and there. It needed to be altered. So the actual undertaking of that work, I would argue, was consideration on the dressmaker's part. Yeah.
Okay.
I mean, normally, if the goods were not exchanged at that point in time, no, then there wouldn't be consideration being given on the part of the dressmaker. But as the facts have said, alterations were necessary. So,
even if you viewed that as one transaction, the purchase of the dress and the alteration, it's still they've still made some progress towards it. So that is consideration. Okay.
Yes. Yeah. That's how I would read that.
Okay.
So if I can jump back a sec, and I haven't really taken you through, how we answer these sorts of questions. Are you all familiar with, how you do answer problem-based questions? Have you looked at that in your other courses, your introductory law course?
A little bit. Yeah.
A little bit?
Yes.
Okay. We'll build on that throughout the semester, but I think I mentioned last week that I prefer to use that IRAC method, which is issue, rule of law, application, conclusion, or the asymmetrical authority conclusion. When we're going through an answer for this, and I have jumped around a bit tonight, you would need to, when you're writing your response, work out what is the issue that I'm being asked to identify here or to address. Okay. Then, in terms of the rule of law, what is the relevant legal theory? Okay. What theory do I need to discuss and explain here? And as I mentioned to students when I'm teaching business law, that is a fairly lengthy process. You do need to go through all of the relevant legal theory and setting out, well, what's the starting position when we're talking about minors and contracting, and then building onto it. Well, the exceptions are when you've got a contract of necessaries and a contract for beneficial services, and explaining those. Okay.
Yeah.
So in the rule of law section, I tell my business students, don't personalise your theory there. Just look at it objectively and explain to the marker what all the relevant theory is in that particular section. Then you move on. Sorry, Michael?
No, you're right.
Okay.
I was just going to say, in this instance, you say you get to the point where it's voidable by the minor, and then you look at the necessity, and you think, is it a necessity? And if you think it's not, that's it. That you don't have to go any further. You don't have to just look at the consideration part.
Well, in the rule of law section, what I was meaning there is, don't look at, when you're providing your legal explanation or your legal discussion in that section, forget about the parties, forget about the facts for that particular section, and then just explain to the marker the theory. Okay, so background me, if you like, as to what the law is that's relevant to this particular issue. Okay. Then when you get to the next section, which is the application section, that's where you personalise your discussion, and you say, well, in this case, the young girl was age 17. Under the law of Queensland, she would be considered a minor. minors, and then you go on from there, okay? And that's when you also start picking up your terminology like necessities. That it's unlikely that this would be considered as a contract for necessities, okay, and then state your reasons. Yeah. It's also unlikely that it would be considered as a contract of beneficial services. Mm-hmm. And Michael, as you also mentioned earlier, it's unlikely that although a formal dress could be considered sale of goods, it's unlikely that that legislation would help in this circumstance, as is a formal dress a necessity?
Yeah.
I don't think so. Okay.
Mm.
Certainly not a $2,000, or sorry, beg your pardon, that's the money's incorrect, but that's for the other client. But I don't agree necessarily that a formal dress is a necessity.
Mm.
Others disagree?
Yeah, I disagree. I disagree on yeah. And just for the sake of argument, I know what we're supposed to be looking at here. Yeah, she's a minor and it's voidable. Yeah, well done. But what I looked at was in the real world. I'm thinking if a client came to me and asked me that, I'd be going, well, is the dress a necessity? Well, she's got the ticket to go to the formal. She's got the boyfriend. She can't turn up in her flip-flops and a T-shirt. So she needs the dress. She's dropped $2,000 cash, made the adjustments. She's good to go. And then mum comes in and cracks the sads 2 weeks later. Well, for me, at a minimum, I would think that we would be able to go to some form of mediation and maybe get some sort of dispensation so we weren't completely $2,000 out of pocket in this case.
Mm-hmm.
I mean, I was looking at that Peters versus Fleming case where the fellow, they decided that the chain for his watch was a necessity.
Yeah.
And for me, I'm going, really? A chain for a watch? I was looking at the same sort of thing. You know, if she's going to a formal, she needs a nice dress, perhaps we could sort of, I don't know, go down that path.
Yeah,
give it a crack anyway, see how it goes.
No, absolutely. And I mean, that case law is relevant. There's those 2 cases on the Cambridge scholars, and certainly that's where your case law and the reading from your casebook does come in handy, because you can see that the facts are, either analogous to some of those cases or can be distinguished from. It's certainly open to argument. I guess that was one of the questions why I posed the hypothetical to Margie before. Do you think it would make any difference if the dress was not so provocative? If it was just a standard, nice, pretty, appropriate 17-year-old dress?
Well, I look at the age of consent, 16. If she wants to wear something that's provocative, go for it. I don't think that's a valid defence. Well, I don't think it's a valid reason to get rid of a contract. She can do more salacious things without a provocative-looking formal dress, completely legally in this state.
Yes. Yep. True. Margie said nothing surprises her these days, and I tend to agree, Margie. Dresses get shorter, heels get higher, but maybe I'm just coming at it from sour grapes now. So,
Can I just ask a question with regards to the IRAC method you were talking about with cases? Having just come out of advanced criminal law, when we do answer these problem questions, aside from the issue rule, with regards to application, should we then be referencing to casework in support of our position on the problem that we're asked to answer?
Yes, absolutely. So it is expected that you would, so let's say you had this question on an exam, it would be expected as a bare minimum those cases regarding the Cambridge scholars you would have discussed and distinguished. Okay. And certainly I take your point, Nick, about, the pins and other items of jewellery, etc., that in this particular case were deemed to be a necessity for that particular scholar. You do look at the participation in life of the individual involved. I guess if you're looking at a 17-year-old girl, it's arguable that a formal dress is a necessity, but I would tend to say, looking at the value of it and looking at the style of dress maybe could be relevant here. So, but open to dispute, Nick.
I think, Your Honour, had seen my point of view when I sort of debated the fact that perhaps my client would be psychologically traumatised if she wasn't able to.
Okay, all right. Yeah. Why am I the only one not going? Yeah. Yeah, look, fair enough, actually. I mean, that if you look at it from that perspective, if you were denied a dress and then in turn denied the opportunity to go as a 17-year-old, then perhaps that is argument why it would be a necessity. Okay. So, agree, disagree? Happy to run with that, everyone? So you can see that it is subjective. So there we go, Nick. I'll award you the point, okay? Rightio. So the second lady, I think, is a little bit clearer. So she's come in and she's the ballroom dancer, and she's paid a deposit on a $2,000 dress which is ordered from the United States. And then she reneges on paying the outstanding $1,800 because she was suffering from a depressive condition that she was unmedicated for. So this is looking at capacity in a different context. It's looking at it in terms of the mental disability side of things. What do we think here? Do we think that it is a genuine lack of capacity or a convenient excuse?
I actually thought that regardless of whether it's a convenient excuse or a genuine lack of capacity, so the seamstress, our client, it can't be proved that she had any way of knowing that this person lacked capacity. So just on those grounds alone, the contract's still binding, I reckon.
Mm-hmm. Sorry, someone else jumping in there?
Margie here. I also thought that perhaps the client did do things which indicated she understood what she was doing. Mm-hmm. In that she tried on dresses. She certainly asked for a specialised type of dress. Mm-hmm. And she picked one out and she knew it had to be ordered from overseas. She paid a deposit and then she rang later and specified that she couldn't pay the outstanding amount. So I felt that she understood the contract that she was making at the time.
Mm-hmm. Yes. And Josh says the contract stands. The shop owner did not know of the condition at the time of the contract. Agreed. I mean, there was no clear indicia or nothing that would make Glenys suspect that the Lady Jenny, was labouring from some mental disability at the time. And again, certainly not to be sympathetic to those with depression, but it is possible to be depressed but still have the requisite understanding or comprehension of what it is that you're doing and the legal significance of what it is that you're entering into. So when we're talking about mental disability, they were really looking at conditions which fragment our mind so that, cases like schizophrenia or dementia, Alzheimer's, where there is a clear disconnect between understanding the consequence of your actions and the state of mind of that particular individual. Okay, so certainly depression, you could enter into a contract and then later, have a different change of mind depending on the circumstances. But I don't think it's a lack of capacity as such. And as you've rightly pointed out, there was no way that the store owner could have recognised that either. Okay. So my view is that contract would stand. Okay. Nick, did you want to argue against me again? See you. You have different thoughts?
No. We'll wear that one. That's fine.
Okay, excellent. All right. So you can see that these scenarios, while we like to have a preferred answer that you come up with, certainly provided that you understand the theory, that you discuss that theory and make a genuine attempt to apply it. Even if you don't get the preferred answer, you will still, do very well in terms of your marking, provided that you do have that discussion and an understanding of the theory. Lovely. Okay, so Mark, your starting point is that the contract made by a person who lacks mental capacity to contract is valid. Okay, so thank you. Well, really, that's all from me this week. Is there anything else that you...
Anna, I just had a quick question on that IRAC method. Is there any practical examples that we can look at to sort of see it flow through?
Yep, many. There's a few textbooks I recommend that my business law students look at, and hope that you've all got access to a law library, presume where you are. But there's a series that was written by LexisNexis Butterworth called the Question and Answer series. If you're not familiar with these already, you certainly will be. And they've also got a nutshell series too, by the way, which are like pocket guides to law chapters that subjects that you'll cover. But the Question and Answer series, there is one on contract law. There's a number of exam problems that are set. Okay, you're given a time indication of how long it should take you to answer those particular questions. You're then given an answer, which doesn't strictly use IRAC, but it picks up on the same, expectations of IRAC anyway, so what you should include in your answer. And then it gives you a checklist, more or less, of what the markers or examiners would have been looking for in that answer.
Right.
There are online, if you Google, and I'll try and put up on the Moodle site for you, if you Google IRAC or how to answer law questions, and include IRAC in that, you'll get quite a few hits with examples there. So
right.
They're the main recommendations I make to my business law students, but I'll try and post some clearer guide for you as well.
Thanks.
Okay. Anything else?
Anna, it's Margie. I just have one question.
Yes, Margie.
One of the cases I haven't been able to locate anywhere, and I don't actually have access to a library which has the volumes of cases.
Right.
I haven't been able to find it online. It's Matthews v. Baxter.
Have you tried doing where have you looked online, Margie?
Through the library, Lexis, foreign England reports. Yeah.
Have you done an Ostley search, or has it come up?
Yeah, and I couldn't find it.
I did that too, and I couldn't find it either.
Okay. And have you done a general Google search?
Yeah, I've tried everything. I've found every case except that one. Okay.
All right. Well, I'll see if I can find that for you and post a link. Sometimes the case reference will be different, to what you've got in your textbook to what it is online.
Yeah, I tried variations of the names and years, different. I've tried all sorts of things and I can't find it.
All right. No, leave that one with me and I'll see what I can do for you. Thanks for letting me know.
Thank you.
Okay, well, thank you very much. If that's it, we'll say goodbye for tonight and look forward to you joining in next week. Don't forget about the semester plans, okay? All right, take care and see you next week.
Thanks.
Bye.